Okay, let's then start. So my name is Victor. I'm here on behalf of Silicon Valley Arbitration Mediation Center Committee, Young Practitioners Committee, and today we're running our tech talk, which became kind of tradition within recent years. And today's topic is going to be crypto litigation, overview of general trends, and DAO disputes case study. With me today are two speakers and two prominent professionals in the IT law area. It's Roman Busko, who is partner of Busko Krasnov boutique law firm, particularly focused on crypto matters and crypto topics, and Shobana Iya, barrister, arbitrator at Swan Chambers, based in London, and also very passionate and very specialized in IT law topics. So without further ado, I will let the floor to Roman, and he will commence today's conversation on the topic which I've just announced. Please, Roman.
Thank you, Victor. Hello, everyone, again. Yeah. So indeed, I lead our crypto Web3 practice, whatever you want to call it, because the label tends to change every other year with every other cycle. It's either blockchain law, crypto law, or Web3 law, whatever it is. I have to say that I'm not a big litigation professional myself, although our law firm and my team handles a good chunk of cases, but I'm mostly focused on startup and crypto companies starting up and advising them on the strategy and advising on them on raising funds. But given this exposure, I definitely do have a good understanding of the general litigation trends that I will talk about today. So in the next 4 slides, I will present you some nice charts that are based on a public article named Crypto Litigation Empirical Overview, which in turn is based on the Morrison Coin Crypto Litigation Tracker, a wonderful piece of data that you can go check out yourself. That has all the information you pretty much need to get a good grasp of what's happening in the crypto litigation world. So this is the first chart, and as you can see, the total number of cases barely reached 70 cases in 2018. Although I have to say that I think, first of all, this is only the US cases in US courts. So the total number of cases in the world is probably much greater than that. And the interesting thing here is that in the red or pink box here is what people usually know as the ICO or token sale boom. ICO stands for initial coin offering. That was the period when companies sold their tokens to the public and made a lot of money out of that. And then at the end of 2017, at the beginning of 2018, the prices went down and decreased significantly. Essentially, the entire crypto market dropped to the lows. And that's when the first peak in crypto litigation appeared and reached almost 60 cases. Again, I think we should better take those numbers as a percentage, not as an absolute number, the rather relative number, because in the entire world, there have been many more cases about that. And then in 2019, 2020, 21, these were the 3 quiet years in crypto. And in 2021, the trend has reversed, has changed. That is the year when everybody heard about the decentralized finance, decentralized autonomous organizations, non-fungible tokens. And I think these were the 3 main trends. And in 2022, we already see some increase in the number of cases. And this data is only based on the first 6 months of 2022. So probably at the end of 22, when this information is reported, the total number of cases will be much higher. And as you can imagine, there is some dependency on the price. When there are significant price moves, there tend to be more cases immediately in the next 12 months that in the case of ICO boom resulted from many investors being disappointed with their investment results. And that's why they were looking for ways to recover the funds, to recover the investments. And that's why they were essentially bringing cases. If we go to the next, about one last piece of information about the previous side is probably we're going to see the next peak in crypto litigation in 2023, as long as the prices, because we saw a significant drop in 2021, 2022, which probably will result in many more plaintiffs in the next 12 months, unless I think both negative and positive price moves will result in more litigation in crypto. Next slide, Victor. This is a quite rather obvious slide that demonstrates that New York and California are the two most important states, most popular states where cases are brought, and the next one being Florida, and obviously Delaware, due to Delaware being the home for many companies.
Is there any particular reason for that? I mean, for New York and California, it's just because they're really popular jurisdictions, or for what reason?
So I think one of the reasons is that founders themselves or defendants would reside in either of those states, because these are obviously the sort of a financial and tech capital of the United States. So that's why that would be one cause for jurisdiction. And another one is that whenever there is a US element in the case that results in a jurisdiction, that would be either a company located in New York or California. For instance, one case that we're going to discuss today about NFTs and about where an action was brought against an anonymous hacker in New York, and their basis for jurisdiction was the fact that USDC, which is a stablecoin, the most known stablecoin and dominant stablecoin, is issued by a company that is based in New York. Circle Financial, the issuer of stablecoin, is based in New York, and the transaction with a stablecoin was the basis for jurisdiction. So the New York courts were appropriate for venue for this case. But yeah, on the next slide, this is I think will give you a better understanding of the type of the plaintiff bar, because almost 50% of all private cases in crypto are class actions that are brought by class action law firms. And I think that should give you a better understanding of the typical plaintiff bar and typical plaintiff in crypto that will be initiated by a law firm seeking to capitalize on a aggrieved class. Not much more to add here. I think this is an interesting slide. This is a breakdown of all the causes of actions, of the most interesting causes of actions. So the most dominant category are the securities-based suits that include violations of the Securities Act and the Exchange Act, along with the violations of the security of the state securities laws. And the second most important category are tort claims that include misrepresentation, fraud and concealment, and conversion. This third most important one are claims arising out of the contract, and those obviously include breach of contract, breach of duty of good faith and fair dealing, and unjust enrichment. And the fourth most common category are consumer protection lawsuits, trademarks, and derivative suits. So I think this is, again, as I said before, data based on the first 6 months of 2022. And I think if we have, if we would have data at the end of 2022, and maybe, as recently as March this year, I think that trademark and IP disputes would constitute a much larger category. And this is due to the fact that NFTs have become popular, non-fungible tokens, and NFTs usually consist of valuable intellectual property. And I think there have been lots of examples of suits brought due to the fact that there was some infringement of copyrights or trademarks that have been a part of an NFT token. And then what 2022 is also known for is the large number of crypto-related bankruptcies, the biggest one being FTX. And I think a large number of cases will arise out of the bankruptcy proceedings, either within the bankruptcy proceedings themselves or related to them. So this is not in this chart, and I think that will should be a large chunk of the potential cases. So this is it from my side in terms of the general trends, and I pass the floor to Shaban.
Yeah. Just before we do that, I also wanted to mention that it seems to be good, how to say, illustration of from which background lawyers could come to actually enter crypto, you know, in the sense of security seeming to be the most prominent part of that. And before we proceed further, just a quick major note that if anybody from audience does have any questions, you can raise them as usual, either using Q&A section, or you can even raise them in chat box as well, but the Q&A section is, of course, a bit more handy. So do ask questions if they pop up in your mind, and we will address them either like right away or at the end of the discussion. And please, Shabana, I would like to, floor is yours.
Thank you. So I'm going to talk about decentralized autonomous organizations, or DAOs as they're commonly known as. Now, DAOs is a general term for a group that uses blockchain and related technologies to coordinate its activities. But in simple terms, you can say a DAO is a novel type of technology-mediated social structure or organization of participants comprised of a variety of composite elements. Now, this is the definition that's been provided by the Law Commission here from England, UK. And it's principally because why we're looking at dissecting this kind of model is mainly because if you really need to look at the different elements to see the kind of flexibility and the kind of novel areas that this can be used in. So you have kind of different composite kind of parts, such as the blockchain system, the software protocols, the smart contracts, the miners and validators, developers, the software protocol token holders, connections with the other kind of external ecosystem, and particularly with the crypto assets, and maybe other entities as well that you might have connected with the actual DAO itself. So although it looks like a simple term itself, it's probably oversimplistic if you look and see about the different forms that it can actually be used. And even if you look at the idea of decentralization itself, we know that while traditional corporate governance relies on management of formal legal structures, DAOs attempt to operate in a decentralized fashion, typically running on public permissionless blockchains and rules encoded in open source software protocols, and which are enforced by smart contracts. Now, DAOs are nascent. Their operations, utility and functions are still there to be defined, and categorizing DAOs is challenging. So I've looked at this, and I really like the World Economic Forum's white paper mentioning, which is detailed on decentralized automated organizations beyond the hype. They tried to categorize it into 9 different sectors, because all DAOs operate based on digital assets, which may be desirable for their financial value, but not all DAOs are themselves oriented towards making money. Some may even are designed to give away money. They can be used for grants, they can be used for a wide variety of reasons. And here they identified 9 sort of categories of DAOs based on their primary objective, so whether it's a generative objective or whether it's associative or ad hoc. And they also break that down to primary means of achieving that objective. So is it by activity, is it by value transfer, or is it by a social community, I mean, all DAOs are meant to be on a community. So in recent years, DAOs have kind of mushroomed across the sectors, serving a wide variety of functions, and DAOs are being leveraged to make investments, network around common interests, even advancing ESG and all other factors. As you can see, there are a lot of philanthropic and all different forms of ways in which DAOs are being used. So DAOs proponents assert that this novel organization form can address the limitation of centralized governance. However, if you think about it as well, the way everything goes along, these three components of a DAO, the decentralization itself, the automation and the organization, they all can have different variations in terms of the ambit and limit of that decentralization. So you might think it's worldwide, anybody can enter it, but it could be under a closed, a smaller group contained, and of course the kind of decentralization, etc., varies. And so does the automation as well, because you can think about what kind of smart contracts are there, what kind of protocols are put in place, does the functionality actually cater, and they cater so differently between different DAOs as well. So you see that you've got so many variables in here that there are different forms and different variations in which they are used. And we can go to the next slide. So, yeah, so if we look at things like what is the legal status of DAOs? Well, we know that several states have decided as to giving DAOs the actual recognition of the legal status. I mean, some jurisdictions around the world purport to give this kind of legal recognition. So we got in the United States, Colorado, Wyoming, Tennessee, Vermont, all giving some form of recognition to DAOs to be able to be incorporated either into a LLC or a blockchain-based LLC is the main ways that they're trying to allow a kind of recognition to limit liability in these organizations and certain organizations. In the Marshall Islands, for example, we have the Non-Profit Entities Act, which allows DAOs to legally register as corporate entities and affords them some privileges as similar to an LLC. And I think as well that we have in places, also places such as Singapore and Switzerland and Cayman Islands as well, although they haven't got entities, they do recognize that there can be this sort of basis in which opportunities have been set up for ownerless entities, because you've got this decentralized form with which and what I'm talking about, ownerless entities, is where you don't have that traditional structure where there are no shareholders and it's not overseen by a supervisor or a management board of directors, etc. And instead they're seen by a supervisory authority who has no ownership of the economic entitlement or foundation itself. So you can see that it's a complicated area as well. And I think what's nice as well is with regard to the model law. So this is an area that's evolving quite rapidly as well. And in June 2021, the Coalition of Automated Legal Applications, Koala, what they're called, was a global multidisciplinary blockchain research and development initiative, published the model law on DAOs. Now, the aim is creating a uniform international approach to the treatment of DAOs, and the Australian Parliament has considered that model law as a possible starting point for developing legislation in Australia. The model law kind of operates on principles of regulatory and functional equivalence that seek to allow DAOs to be accommodated in different jurisdictions by establishing what we would call a minimum level of rights and duties and protections that are generally recognized in legislation on analogous corporate entities in major jurisdictions. So it kind of proposes that DAO should be afforded separate legal personality from their members. And it also includes DAO-specific provisions concerning contentious hard forks and restructuring about the updating or migration of the DAO's underlying smart contracts and failure events. So there's a lot going on in there. As to the UK at the moment, the UK is currently, does not currently grant any kind of special legal rights, but the Law Commission here is undergoing a project now, with the current project, in which it is looking into DAOs and seeing what sort of form or what kind of a legal form could they take. It is still in the call for evidence. I think the call for evidence is supposed to have finished on the 25th of January, and we should be getting a consultation out. But I've noticed that I think people can still submit it until tomorrow. But I think it's officially closed. I'm not sure why the portal still allows you to continue putting some more applications in. But essentially,
I just wanted to ask a bit of on the legal status, in the sense of, of the framework which we usually haven't had, of what you cited on US law side. It seems to be kind of fight between like just statutory law, and it seems to be, if we do not have statutory law in place, which is current position for majority of states, and for example here in UK as well, we do not still have here where you and me based, so we do not still have any law which underpins DAOs. So it seems to be the common law objective then, and it will come most likely to the general partnership. But then we have states which say no. We're saying that this is just type of LLC where some solutions are taken off-chain, but many solutions are taken on-chain, and on-chain elements make it to be actually a DAO. So I will try to put this comment into question. The question is like, how we, what is your view on how maybe we should categorize DAOs in the best way? Should it be still partnership, or should it be limited liability company with on-chain elements, or something else?
So it's a difficult situation, because, as I said, it depends on the DAO, how the DAO is structured and what it's actually purported to do. Because in the absence of any kind of formalized legal corporate entity or whatever that you could try and attach to the part of the DAO, so there are sort of like software developers, etc., trying to set up a company that incorporates to go back into a traditional corporate company for that part of it, to try and limit their liabilities, etc. But in UK, obviously, a DAO might most likely be considered at this point of time as a general partnership, depending on how it's formed and operates, and the general rules of partnership, which is governed under the Partnership Act, and the ones on one rises where two or more persons carry on business in the common view to create profit, and there could be the formation of a general partnership is a question of fact, obviously, which is relevant to the actual agreements and the treatment as indication, rather than the confirmation of partnership itself. So it really depends on what the DAO system is, and how could you try and limit certain parts of that liability. And this is why sometimes there are some DAOs created. So it is an area which is under exploration, but it's also one of those situations where I think you have to really think carefully about the regulatory factors as well that might go into that area. Okay. So it's a battlefield at the moment.
Thank you. Roman, you wanted to add something, or?
I find myself like twice or three times a month in the discussion about whether DAO should incorporate an entity. And usually there are three main considerations at play. First, sometimes a DAO or collective needs to interact or cooperate with the so-called real world, which includes entering into contracts, entering a bank account, registering a trademark, entering into intellectual property assignment agreements with the main developers. And this is one of the first reasons why teams consider opening a legal entity. The second one is limitation of liability, because presumably having an entity in place will limit the liability of individual members. And the third one is the taxation. again, if you have a legal entity in place, presumably you will have a sort of a subject for taxation that will bear the tax burden. But I recently heard an analogy that I would like to still borrow for our conversation. I think a legal entity for DAO is similar to a blanket. When you will cover yourself, you still have your toes sticking outside of the blanket. And that's the same, very similar with the DAO, because although you create a legal entity, you still have other parts that might not necessarily be covered by this blanket, that will still exist in the social environment and maybe viewed as a part of the DAO. For instance, let's say you have a multi-signature wallet, and 3 of the 5 members are, let's say, trustees of an association or a foundation, and 2 of them are not. Or let's say activities of a DAO are more prevalent in one jurisdiction, and the offshore jurisdiction where some of the DAOs also register only, relates to a small unimportant activities. So it's not always really clear if you create an entity whether it truly covers your entire operations, or you still have some parts of it that sticking outside of this corporate blanket. But yes, Shaban, I agree on what you said. That's very interesting to see what's the developments in the UK.
Yes, because it's as you say, it's complicated. I mean, if you know exactly what a DAO is actually doing, and of course we got other kind of structural forms like unincorporated incorporations, as well as trusts that are also being considered as well. And as you say, it really depends on the particular DAO and how can you limit liability. And I think your analogy is wonderful, actually, with regard to the blanket, trying to be like hidden, kept away, but it's still the idea of the fact that there are going to be certain parts that are still connected and this is where the question comes again with regard to whether it's really that decentralized or not. And of course, this is where I come on to the kind of floor or scope of liabilities and areas of legal kind of issues that can come up. And as you mentioned, Roman, there can be lots of kind of areas. So you've got the regulatory scope. You don't know which, depending on what type of DAO you got. If you've got an investment DAO, if you're dealing something on stable coins, etc., connected with that, you probably have other regulatory stuff. And there might be other points of regulatory stuff when you're doing NFTs as well, with regard to any kind of media, advertisements, those sort of things. So, and of course, which are the applicable laws? Have you got that put down in your smart contract? Have you agreed? What is it? Jurisdictional issues as well that come into play. We know about cybersecurity as one of the kind of other major areas that have been coming, particularly even with the DAO from the 2016 hack. And I think recently, I wouldn't call it more of a hack in that way, but it's about the mango markets, where a trader managed to manipulate the trading function of that. So there are all sorts of areas. And of course, governance as well, in terms of the voting rights, all the kind of issues that we think about that can be made more efficient, what we're hoping for in the DAO, if it's not done properly or whatever, voting rights between the token holders, etc. There can be issues coming up on that. And as you mentioned, taxation, tortious liability, we've heard things about, negligence of developers, etc. And then you've got the all kind of flaw of, as we mentioned, intellectual property rights when you got connected with those kind of assets, etc. There are issues about consumer protection law, and whether, how much that actually comes into the actual DAO itself. And then we come over to dispute resolution. What forms of dispute resolution can you really deal with? Is it just going to be litigation, or is actually arbitration? Have you agreed to a form of dispute resolution, alternative dispute resolution? And even if you haven't, which jurisdiction do you think you can go and sue in, and all those sort of issues that come up?
Oh, yeah. So that we revised. Just to make intermediate points for the audience, and in the sense that DAOs are very complex. And I would say that our maybe objective here is kind of make it a bit more exciting if you was not excited before you joined this webinar, or if you watch it in the recording. So the idea is that if you're interested in any particular area of law, you might still find something interesting about decentralized part of how to say business practice and like just people's life coming around. Yeah, it can be in sports, it can be in games, it can be in banks, it can be in advertising, in legal practice. Actually, there's Society of Lex Punks, who currently I haven't read their particular, how to say, articles, but of association and how they operate. But I think it will be very interesting and exciting. Yeah. So
Yeah.
Roman, then we will then speak a bit more about specific cases.
Yeah, thanks, Victor. Shabana, building on what you said about difficult jurisdictional and applicable laws issues, I think let's go through 3 case studies that I decided to bring today that I found particularly interesting for this webinar or for the audience. So the first one is probably, I think, the first ever case where a regulator has brought an action against a DAO. And in this case, the CFTC, Commodities Futures and Trading Commission in the United States, brought an action against DAO or OKIDAO. This case is very interesting because I think CFTC has made a very artful procedural move. They announced the charges against the 2 individual founders of the OKIDAO who were behind the scenes, and they immediately settled with them. And they then simultaneously announced and proceeded with an action with a lawsuit against DAO itself. So they essentially took out 2 of the defendants who could potentially defend themselves out of the scene, and they moved to score the points against an amorphous and defenseless defendant, which is in this case OKIDAO. As you on the right side of the slide, I put a tweet from a prominent crypto lawyer, Miles Jennings, who's I believe the general counsel at A16Z. So he said that CFTC has actually manufactured a defendant in this case to score the points. I did not see this tactic in play before that and found it particularly interesting. So the first question that CFTC faced in this case was how to notify an amorphous structure such as a DAO. And they relied on the alternative service in this case and notified a DAO using a chat box on their website, governance forum, and a Telegram chat. And when they did so, they filed a motion simultaneously with filing a lawsuit. They filed a motion to allow alternative service, which was granted because obviously no one could have opposed it. Despite the fact that there is no counsel and no one has appeared on behalf of the DAO in this case, several industry participants filed their amicus briefs to oppose the alternative service and the theories of liability. And one of them is LexPunk, another one is DeFi Education Fund, and I think Paradigm Venture Capital Fund, and I think A16Z all filed briefs to assist the court in this case. The court will probably enter into default judgment, and the main question will be is how the judge will draw a line on who can be held accountable on behalf of a DAO. In this case, the DAO in the lawsuit brought CFTC, a DAO is characterized as an incorporated association, and CFTC wants to hold accountable all token holders who exercise their token voting rights, which in this case, I think gives us sort of demonstrates that CFTC understands that not all token holders who just hold those tokens necessarily participate in the governance of the DAO, because as yeah, as those of you who are familiar with the crypto and Web3 know that tokens could be dropped on any digital wallet without the consent of the recipient of those tokens. So the fact that they narrow down the category of DAO members is very interesting and I think thoughtful. And I expect that in this case, the judge can potentially narrow it even more significantly and yeah, the category of DAO members. So
just before, may I pop up with the question, Roman? With the just have it, if they say that it is the same as a general partnership, from my end, I would maybe, if I'm speaking on their behalf and being their like advocate, to say that okay, then all DAO token members, what we have written in the DAO white paper or in the DAO constitution documents, stating that how you become DAO member. If you hold the token, then that's it. You are a partner, and you are like responsible for like any action so whatsoever. If we call DAO for the purposes of like something general partnership, then I do not see legal basis. It's going to be kind of ad hoc rule, it seems to be, or it's going to be very precise deviation in common law, in the sense of, because general partnership is usually general partnership. It's impossible to be how to say limited partner in general partnership.
Right, I see where you're coming from, but I think the main question here is not about the legal nature, let's say, of a DAO. I think that what CFTC wanted to demonstrate and prove and set an example is that you cannot avoid liability by transferring part of the activities to the DAO. If you read the lawsuit of CFTC, they really do a good work of citing the governance forum of the DAO, and the various charts where DAO members are actually getting excited about how they call it, transferring their project to the DAO and thus becoming invincible to the regulatory attacks. And then CFTC made it clear that you cannot avoid liability by doing something through a DAO. So DAO is no defense and no shield from potential regulatory actions. I think that's what CFTC is trying to prove here, and that's their main point. I think that's the dispute is less about the nature of the DAO as a general partnership or some sort of incorporated association.
Okay, thank you. That's really interesting how they will make it out, because if my concern was more not, I mean, I understand this in the terms of like just legal principles, in the higher level, but if they would put like general partnership as kind of closer look at the picture than saying that somebody avoids liability in general, and we will look at general partnership closer. If we take what your example from the forum chats, for me, the closest to come will be to say, okay, then it seems that you are, they were partners, let's say token holders were partners who discussed that, who kind of, how to say, were in breach, not only in front of like regulators, but also in eyes of other partners, who, for example, did not consider to break the law, who just thought that they do something legal, and do some nice investment which will pay out later, and we're not involved in these particular discussions, something like that.
And another aspect potentially, building on what you just said, is that how do you actually differentiate between like a, let's say, token that you can potentially have and let's say a private Telegram chat where you have been invited? Does that also make you a partner in some sort of a partnership? Because voting, functionality of voting can be facilitated through tokens, but their social medias usually also allow you to set polls and then have votes. Let's say a Telegram chat, right? It's an example. It's a private chat, invite only. You have a vote, and you vote about doing something. Does it make this chat a general partnership? I don't know. And then I think the token technology here is not the defining principle, is that like the not defining feature of a DAO, or we'll see how it goes. I think you can build a lot of analogies based on this case. But as I said, what's really interesting that I think 3 or 4 really strong amateur briefs have been filed in this case, and the judge is really taking them seriously. So I expect a very thoughtful judgment in this case.
Great, thank you. Shabana, if you wanted to add something, or because further we will move to NFTs filings, which is also very interesting topic.
Yeah, I mean, just to mention here that when determining whether English court has jurisdiction in a civil or commercial dispute, on a number of factors may be relevant, and that depends on the nature of the dispute and the regime in play. So these factors may include the place of domicile of the residence of a party, and the place of performance of a contractual matter, or the location of the assets. And sometimes these factors are not readily determinable when looking at DAOs, particularly where there's no registered office or seat, or is governed by a protocol that is written into a decentralized blockchain, or it's comprised of anonymous participants who are located all around the world. And it's particularly if it operates automatically by smart contracts in a decentralized system. But usually there would be some kind of human component in there, and some form of registration of the address, etc. But saying that, I mean, English law allows, obviously, actions against anonymous people, and can easily deal with DAOs as well, and we know that pretty well. With regard to service out of in different forms, there was a case back in 2009 here in the High Court called Blainley versus Persons Unknown, and the High Court there, Mr. Justice Lawson actually allowed the claimant to serve an injunction against anonymous Twitter user for sending a direct message containing a link to an injunction. And this was understood, I think, to be the first English case involving the use of any form of social media as a service of proceedings. But even recently, we've had, you know how draconian bankruptcy proceedings are. And recently, there's been a case where a county court judge has allowed, has allowed the service of a summons for examination on a bankrupt debtor to be provided by also with regard to the effect on substituted service. So it looks to me that, you know, it's much more open here. And I think more importantly, with regard to the crypto space, we have the famous Osborne versus Persons Unknown case. And this is a case where it's alleged that the claimant's wallets held an account with the crypto asset management platform where she had NFTs, MetaMask, and alleged theft of two NFTs from that. And she managed to get an injunction. First of all, I think it provides, another thing the English courts have said is that crypto assets can be considered as property, and particularly NFTs, but also the fact that she could serve that, as Roman said, she could serve the order of the NFT directly on the wallet itself of the hackers side of it too. So it's
I was going to say that's a great introduction for our second case study here, because it is about exactly sending a service, doing a service by dropping an NFT. So in this case, in January 2022, a Liechtenstein-based cryptocurrency exchange, LCX, was hacked for almost 8 million. And the hacker obviously was anonymous and unknown. And then the exchange engaged a few analytics companies and private investigators who have been tracking their transactions with the wallet and with the assets stolen. And at a certain point, the hacker has converted some of the stolen funds into USDC, which I mentioned at the beginning of our webinar, is a prominent stable coin backed one-to-one by US dollars. And the coin there is actually issued and administered by a US entity based in New York, which is Circle Financial, there's also a consortium behind it, but for the sake of this matter, I think it's enough to say that there is a US entity based in New York. So that was the basis for jurisdiction, in this case for LS6 to engage a law firm whole night to file a preliminary injunction in New York courts to block access to USDC tokens. They had to notify and they had to serve the defendants in this case, and they came up with an idea of doing this by dropping a so-called service token that would contain a link to a law firm's website with all of the materials, procedural, the pleadings and papers in this case. All the links are available, and I suppose, Victor, we will share the slides with the audience, and they can read their documents and can also go and see the NFT token itself. So two important things about this case, two important aspects about this case. First, it's really a pity that they didn't incorporate the picture in this NFT token. I would expect them to put some sort of an interesting picture. Instead, they decided to put a random gray background with NFT on it. I would really hope to see some sort of a angry man giving you a letter, or a postman, something
maybe there was such a battle for, you know, best picture that at the end of the day they said, okay, we are not going to put anything there.
Right.
Probably frightened to infringe copyright or something.
Yeah.
That will be funny if the lawyers getting sued for like infringing copyright while defending somebody
with
with
an NFT token.
Yeah.
Right. So essentially, you can see this token itself on the right side of the screen, and then it simply contains a link in its metadata. It simply contains a link to the website, as I just said. So the question, the larger, I think, aspect development here potential that we can see in the coming years is that blockchain wallets and addresses can potentially become a valid method of serving parties in any dispute, because despite the fact that there is a anonymity ethos in crypto, right, and everybody thinks that transactions are anonymous, insiders are well aware that there are many, like thousands of analytics companies and investigators that collect data about blockchain wallets and are able to triangulate the data to such an extent to narrow down to a specific individual who could that be. In my experience, we have engaged a private investigator who really helped us find a very significant amount of data based on the on-chain activities of the wallet itself. So you would know in which token sales the party participated, which transactions this token holder actually entered into, whether there were any interactions with the centralized exchanges, because if there was an interaction with a centralized exchange, you would definitely can request a centralized exchange to provide information about the potential owner of this wallet. So it will be interesting to see, and I think wallets are becoming a bigger part of crypto. Some people say that wallets are becoming our CVs, resumes, or even as our second digital identities that will aggregate and link to many other valuable data. And it will be interesting to see, well, there will be also an opposite trend where you would try to hide your or to make sure there are no, you're not leaving any ways to sort of notify you. I think that's an interesting development. They also cited in this case that that they've been recent transactions with the wallet. So to prove that the wallet is active and it's been actively monitored by the owner, they demonstrated that there've been recent transactions with the wallet to sort of show that it's been active and
but
the service will be proper.
In that case, it seems like they just tracked transactions up to this address, and then they didn't have any other links to the hacker, but the address of the wallet, and they basically decided to serve it, in such a way. Is it? I understood it correctly, yeah?
Right, that's correct. And then the latest development, I think I checked it this morning, and the latest development that there is a counsel on behalf of the defendants who appeared in the case on behalf of sort of unknown defendants, and the exchange, the lawyers for the exchange moved to compel the counsel to disclose the personalities of their clients if they know, or essentially get out of this case, sort of
Okay. So other way around, it's going to be we served on a wallet, and then the wallet owner served the request for like instructed lawyers via other wallet, and then they just say,
Right.
we do not know, we just know the wallet address. That's not enough.
Right.
No, that's not maybe enough for your purposes of representing somebody.
Exactly.
So that okay, so basically, yeah, so they appeared the representative, but he said that he is not going to disclose or he just was not forthcoming with the disclosure. Yeah, is that the case?
Yeah, indeed, it is. I think that as I said, the other counsel moved to compel the lawyers for defendants to disclose the identities. But in this case, I'm not even sure if the Hikers counsel is actually aware of the identity of the clients, because in crypto, it's quite common that for lawyers working in crypto, that you would get a message, let's say anonymous message in Telegram, asking you a number of legal questions, asking for advice and willing to pay, but not willing to disclose its personality. And then you have this ethical question or whether to take it or not, and how to deal with that without knowing the identity of the client, which is an extremely tricky ethical question.
Yeah, that's true. Okay. I don't know, Sharbana, if you maybe have something to add here, but or we can can then move to. I think we better move to actually, because we're a bit ahead of time.
Okay.
Yeah.
I mean, I think a similar case here, why you changing that, I think a similar case, the Osborne case, which I mentioned, I think as Roman is saying, we've got a lot more detective investigators being available now to try and trace the NFTs or the assets, the crypto assets, and where the judges can actually give you what's called bankers' trust disclosures against the exchanges as well to provide the information.
Yeah, that's really interesting. From the it seems to be that English law is kind of better into the business of serving, serving on the parties, just because the English law jurisdiction is kind of trying to get overseas. Yeah, so let's turn then to the next topic. Yeah, Roman, please.
Well, this is the last case, and I have to say the only reason I brought up this case is that there was potentially pretty much the only case that could have ended up in arbitration, but eventually it did not, to the best of my knowledge. Although then I have to say maybe it did, because the proceedings in the LCIA are confidential. So maybe somebody brought a case against a suit against Telegram, but I am not aware of any cases. So this case resulted from the shutdown of the token sale of Telegram that happened back in 2019. At that time, Telegram offered a broad audience. No, I'm sorry, not the broad audience. So they offered a simple agreement for future tokens or token sale agreements to accredited investors in the United States and internationally. And at a certain point, just I think a few weeks before they were going to distribute their tokens to the accredited professional investors, this SEC got I think an injunctive relief and shut it down, essentially prohibiting them to proceed with distributing their tokens. And that's when the prolonged litigation in the United States started. It ended up in Telegram losing an appeal, and I think they didn't even go into appeal. They dropped the case at that point. So, and they had to return all the funds to their investors. But by that time, I think they already spent almost $500 million on the development. So they couldn't return everything. Out of their 1.7 billion raised, I think they could only return something like 1.2 billion to their investors. And obviously, the contract actually allowed them to do that because there was a provision that if they eventually had to return the funds to their investors, they can deduct all expenses related to litigation and development of the platform, which in this case was the case. But some of the investors were really disappointed that they had to take almost like a 35% cut from their initial investment, and they were actually considering going to LCIA. We've been representing a number of investors in this case, and I know that despite the fact that the agreement that Telegram entered with many professional investors prohibit those investors to resell or assign the rights and the tokens to the non-professional or to any other third parties, there have been a lot of arrangements on the market that would effectively give the participants would sort of transfer their future rights and tokens to other market participants, essentially selling them with a premium because those small investors couldn't get in the initial batch of investors. So that resulted in many small investors out there who were unhappy with the results of their investment. And I think that was one of the reasons because they couldn't coordinate, and then maybe even the case was not very deemed to be successful, or didn't have really chance of being decided in their favor. So that was the case. As I said, potentially a big litigation in London, but didn't work out.
Yeah, on that point, I would suggest just to take a few quick notes on the arbitration potential. Maybe started to compete with litigation, which is way ahead. If it was basketball play, we're already like many balls to get.
Yeah, I mean, where I say Victor here is because we know very well arbitration has benefits, particularly on the international global scale, particularly with regard to enforcement, if you've got a proper award. And I say proper award, and I'll come back to it. But there's also the issue of, to get specialized arbitrators as well. So that usually helps. But the main concerns, I would say, between arbitration, particularly in this space at the moment, why we have a lot of fraud and other matters going on, is the question about, I would say it's threefold. It goes around arbitrability as well. So you could say four sides of it, but because we know that arbitration has to be a conscious agreement between the parties. Now, what happens when you have these third parties, when you have hackers, when you have other things, other parties put into place? You don't have an arbitration agreement in place. So we have that sort of problem. The second problem is with interim remedies. We know historically court-based routes have helped to clarify the legal context surrounding crypto assets, decisions relating to the classification of the crypto assets or the subtype of property that's arisen in the context of English decisions. And of course, the ability to give freezing orders and bankers' trust orders for such properties pending the outcome of these cases. So there's a big question mark about how effective can you get interim remedies available in this. I would say it's still possible, but it really depends on which parties you've got agreed to the arbitration agreement and whether you can have emergency arbitrations put in place that's quick enough. But the other issue that's really come up, particularly here in the English courts, is this concept of consumer protection. You probably have heard about the case of Solimi versus Nifty LLC, and the Competition and Markets Authority are intervening in this. But this is a Court of Appeal case where it considered that the relationship between the legal framework for consumer safeguards and for international arbitration, and in the similar way, a later decision, that's a later case of Chechetnin versus Payard, where the English courts have kind of accepted that the jurisdiction to actually litigate where arbitration agreement was in place. Actually, very rare are these sort of cases, and where the English courts actually intervene. And this is because they consider they got issues with regard to consumer protection rights. So we have the Chetland case, for example, where the claimant, a senior lawyer, actually signed up to arbitration, and arbitration's proceedings were already concluded, and then the tribunal had already rendered a final award dispensing the claim. In this court case, the claimant successfully defeated the jurisdictional objection of the defendants, that's the cryptocurrency trading platform, against English courts on the basis of the terms and conditions of the platform for which the claimant had signed up to mandated overseas arbitration in San Francisco, California, under the JAM rules. So you can see that there can be kind of issues with regard to consumer protection as well. So I'd say third-party interventions, interim remedies, and consumer protection are the ones that are actually kind of barriers at the moment, challenging international arbitration. But otherwise, I think it's a very good tool, particularly with regard to enforcement under the New York Convention, rather than, and you know, you've got much more places that are easier to enforce than you have a court judgment.
Yeah, thank you.
Yeah.
Thank you. Yeah.
Right. I think that arbitration and mediation are a feature of a well-developed industry where the participants can come along and agree on their effective dispute resolution method and submit to this third institute that will consider their disputes. And I think, unfortunately, crypto is far from that stage right now. So I think that's, in my view, although there is, I do think there is a potential for arbitration in crypto, but that definitely depends on the consciousness of the participants and trends that we will see in the future. So on the slide that you can see, there are two wonderful resources for those of you who want to learn more about litigation in crypto. On the left side, it's a website called Code 3X, which positions itself as an open source digest of crypto law, or US crypto law. And they recently launched this litigation tracker there where they keep track of all the major cases. On the right side, this is the Morrison Coin litigation tracker that I think the latest edition was issued on February 10, 2023. And that's the best resource on crypto cases and crypto disputes out there. Definitely go and check it out if you are interested.
Yeah, Roman, before we think through this as well, and we actually have a question on the chat box. I can read it out for you. It says, Roman, could you please clarify why the SEC abandoned Telegram's crypto project? What were their arguments?
Oh, no, the SEC did not abandon the Telegram project. So the SEC prevailed in the trial court, and then the Telegram was going to challenge it and was going to appeal. And I think they dropped, the Telegram actually dropped their appeal. So that it was not that the SEC who abandoned the project. It was Telegram who did not eventually did not go to appeal it, although they initially were threatening to do that. What is interesting about actually Telegram project is that the Gram token is still out there. After 5 years, after 4 years, we know that the Gram token exists, and then that it was sort of the development of the project was picked up by an anonymous independent team, and they managed to build this technology, so it exists out there, and yeah, we'll see how it develops. But I found it's really interesting because the Telegram is no longer involved. At least they claim that they are no longer involved, but the project is out there. But their token is not. Yeah, you know, it's really difficult to find. You can't really buy it anywhere because exchanges do not want to list it, because there is a negative case law saying that this token is a security, and then centralized exchange will never list as something that is a security. So I think this case is actually did not end in 2020. and we it exists out there, and we might see some other potential interesting developments in this regard.
Yeah, thank you. So colleagues, I do have lots of other questions, but we actually just quite a bit of time ahead of, not ahead, but otherwise other way around. So if you have some closing points, please do. Otherwise, thank you very much for spending your time today. We will have this session in recording, and we will be able to circulate it further for any interested parties. And yeah, thank you very much for being with us today.
Thanks for inviting, Victor.
Yeah,
Yeah.
thank you, Victor. Sorry, I just
yeah,
bit cold nose, but apart from that, sorry.
no, it's fine. It's fine. It was totally fine. So on that, I think we will wrap up, and thank you to the audience. Thank you to the questions, and you will find this recording on the official Silicon Valley Arbitration Mediation Center YouTube channel, and we'll be able to access it later on. And if you need slides, you can come like just drop us a message, and we will be in touch with you. So